Good afternoon, everybody, and welcome to another live question and answer session. My name is Samara Belitzky. I'm a lawyer at Samfiru, Tumarkin in our Ottawa office, and I'm here for the next 30 minutes or so, as usual, to answer all of your questions related to employment law, workplace issues, terminations, severance, questions about severance, health and safety issues in the workplace, COVID-19 related concerns, whether that be masking or vaccine policies or vaccine mandates, whatever the case may be. If you have a question, please do send it in. I'm going to be here for the next half an hour and I'm happy to answer. Before I already have a few questions coming in. Before I get to those questions, there is one thing in particular that I did want to discuss today. It's a bit of a hot topic that's been in the news this week, and that's with respect to the federal government suspending the vaccination mandates that they had in place. Now, most of you watching are probably aware of the fact that they did announce this week that they're going to be suspending the travel-related vaccine mandates. Specifically, what we're interested in for the purposes of what I do every day, which is employment law, we're looking at the fact that the federal government has suspended the mandate for all federal government workers and contractors to be vaccinated in order to work. So that was a mandate that the government put in place. They changed the law essentially last year with respect to the core public administration, meaning the vast majority of federal government workers, as well as contractors, had to be vaccinated in order to continue working. So that was in place last year. We've heard from a lot of people in those positions since then. Of course, we're not able to assist people who are unionized, unfortunately. So we can assist people who are not unionized. And in the federal government setting, there aren't that many. But for those of you who are not unionized, if you have been impacted by this, absolutely you should be getting in touch with us and we can do our very best to assist you at this point in time. And that's because previously, the federal government actually changed the law when they put this mandate in place last year. So if you are a federal government employee and you are not unionized and you were put on an unpaid leave last year because you are not vaccinated, the impact of the federal government now removing that mandate or suspending that mandate as of June 20th means that you should be called back to work. And if you're not called back to work, that's going to be an issue. So all federal government employees moving forward as of June 20th should be called back to work. If you're not called back to work and you're not unionized, then definitely get in touch with us and we can assist you with this issue because it's no longer the law from a federal government perspective. It's no longer the law as of June 20th that an employee that works for the federal government or a contractor needs to be vaccinated moving forward June 20th. So keep that in mind moving forward. As I said before, it applies to contractors. So a lot of contractors contacted us throughout the last 8 months or so with respect to this issue. Unfortunately, our hands were tied from a legal perspective because the government actually changed the law when it comes to this issue, but they're changing it back now. And so moving forward, if you're a government employee and you're not unionized, or if you're a contractor for the government and you're not able to continue working because of a vaccination related issue, definitely get in touch with us. We can assist you in terms of either getting you back to work or going after your termination entitlements. So keep that in mind moving forward. That was a very important announcement that came in the news this week. Obviously, I'm in Ottawa, so a lot of federal government employees in Ottawa, a lot of contractors in Ottawa. It's a bit of a hot topic in Ottawa, but I expect that it will be just as important throughout the rest of the country. So do not hesitate to contact any of our offices, depending on where you are in the country, in order to get assistance if you fall under that category and you're not able to work as of June 20th moving forward because you're not vaccinated. All right, so I have a lot of questions coming in, so I'm going to now get to the questions and do my best to answer as many as we possibly can here. I have a question from AJA on YouTube who says, I'm on a 4-week paid leave of absence for vax policy non-compliance. HR said that my health and dental benefits still continue and that it's mandatory for me to contribute to my defined benefit pension plan while on a leave of absence. And I see there's a follow-up here. Should I contribute and wait for termination or not contribute? Excuse me, consider constructive dismissal and fight for severance now instead of waiting for termination to do it. Termination is in 3 weeks. All right. So in terms of your situation, if you are going to be terminated, sounds like it will be for cause, meaning your employer is not going to be giving you severance pay. If that's going to happen in 3 weeks, I would recommend that you wait those 3 weeks in order to pursue it at that time if you want to go after severance. So if you're terminated for cause for not complying with a vaccine policy at work, a discretionary vaccine policy that your employer is implementing on their own volition, if that's the case, then they wouldn't have cause to terminate your employment. And when I say that, I mean that usually when an employer is terminating for cause, they're relying on the fact that there was egregious misconduct or some sort of misconduct. From a legal perspective, an employer has the burden to prove that they had cause, to prove that what the employee did was so egregious, was such a breach of trust that the employment relationship simply cannot continue. And historically speaking, when we look at the case law that addresses this, termination for cause because of a failure to be vaccinated doesn't quite hit that threshold. Now, it's important to know that this issue hasn't gone to court yet. There are no court cases related to either a constructive dismissal for somebody that was put on an unpaid leave for not being vaccinated, or someone who was let go for cause for not being vaccinated. We expect that there are going to be a bunch of these cases that do go to court eventually, but they haven't gone yet. So when we're looking at this issue, it's important to keep in mind that it is a novel issue and that the law can change on these things. What we're addressing right now is the current state of the law, and how does the current state of the law apply to these situations? So getting back to your question, you absolutely could pursue a constructive dismissal as a result of being put on an unpaid leave for not complying with a mandatory vaccination policy. That is an option that's available, and it is a good legal argument in terms of arguing that by the employer putting you on an unpaid leave or a layoff, preventing you from working, and refusing to pay you, that would amount to a termination of your employment, a constructive dismissal. And in that circumstance, the result of that is that you would be pursuing your severance as if your employer had outright said to you, you're fired. So that is an option. And for most people who are put on an unpaid leave, it's usually an indefinite leave, in which case I would recommend to people in that situation to pursue it as a constructive dismissal immediately. If you are in a situation where you have a 4-week unpaid leave, like you said, AJ, and you know that you're going to be terminated in a few weeks for cause, I would actually recommend that you wait. Again, unless you want to keep working there. If you want to keep working there, then I would recommend that you contact us right away and we can try to assist you in getting back to work. If that's not the case, then I would wait until you're terminated for cause, because then you would be able to have a much stronger case in pursuing your severance. So you have those two options. If you are going to wait, get in touch with us right away so that we can help you and make sure that you have a strong case for when it comes time, if it does come time, to pursue your severance. Now, your other question was with respect to the defined pension plan. So the reason for continuing to contribute to the defined benefit pension plan is so that it's available to you come the time for it to be available. If it's not something that you're going to be availing yourself of, and you anticipate your employment's going to be terminated in a few weeks, you may decide not to continue contributing to that. So that is a personal choice. You have to look at the terms of the pension plan, and it would also depend on when you're going to be close to retiring, when you'd be able to retire, when you'd be able to access that defined benefit pension plan. If, for example, you're close to retirement and you were going to be able to access that very soon, then you will want to continue to make those contributions to make sure that it's available to you. If you're nowhere near retirement, you're not going to have access to this plan anytime soon, then it's not something that's of much importance. And you wouldn't necessarily have to continue contributing in that situation. So it really does depend on your specific circumstances. If you do want to discuss it further, get in touch with me. You can go to employmentlawyer.ca, which is our website. All of my contact information and all of our other lawyers' contact information is on our website. Again, it's employmentlawyer.ca. So you can look up my contact information, get in touch with me directly. I'd be happy to set up a consultation with you and discuss this issue further, because there's a few moving pieces here, and you want to make sure that you are in the strongest position possible with respect to your employment and your termination, as well as your pension plan. Just moving on here, I have another question from YouTube, from Sergi on YouTube. How can non-unionized bank employees who have been put on unpaid leave of absence over refusal to get the vaccine best protect themselves when called back to work? Okay, so in terms of bank employees, it's important to know that there was no government mandate with respect to the banking industry. There was a lot of talk about this, and this is why there is a lot of confusion about these government mandates at the federal level. There was a lot of talk from the federal government about making it mandatory for all federally regulated sectors, employers in the federally regulated sectors, to have mandatory vaccine policies. In fact, I believe it was part of Trudeau's re-election campaign where he was running on this particular platform. But at the end of the day, this actually hasn't happened. And I do think there was an announcement, it might have even been today, where they've said they're actually not going to be pursuing that any further, which I don't think anyone is surprised about, given that they just announced that they're suspending the other mandates that they put in place. So generally, when we're talking about federally regulated businesses like banks, telecommunication companies like Bell and Rogers, financial institutions, like I said, banks, aviation. Aviation is separate, but many of these are federally regulated businesses. Now, the only mandate that came into place for federally regulated businesses is with respect to transport. So businesses in intra-provincial transportation, trains, planes, trucking transportation in some circumstances, those businesses were essentially mandated by law, by the federal government, to have mandatory vaccine policies in place, and for the employees to have the COVID-19 vaccine. That's the only industry other than the actual federal government that was mandated by law, by the government. So banks and telecommunication companies, for example, were not actually mandated by law to have these policies in place. So if you work for a bank and you are subject to a mandatory vaccine policy, you didn't have to just simply accept an unpaid leave of absence. You have a choice. You can accept it and hope they call you back, which is what I think is happening to you, Sergi on YouTube. But you also had the option to consider it to be a constructive dismissal of your employment and pursue your severance on that basis. So I think that's really important for everyone watching to be aware of. Many, many people think that all federally regulated businesses were forced to have their employees be vaccinated, and that's just not the case. There was a lot of talk about it, but it was never, it never came into law. It never actually happened. So if you're going back to work, if you've accepted an unpaid leave of absence, you decided you're not going to claim constructive dismissal, you're just going to accept it. If you're going back to work now, to protect yourself moving forward, what you'll want to do is, in writing, make it clear to the employer that this was a one-time unpaid leave. You are not agreeing that moving forward, the employer is allowed to lay you off. You're not agreeing moving forward that putting you on an unpaid leave or a layoff is a condition of your employment, and that this doesn't create a precedent moving forward, as this was a very exceptional situation related to the vaccine. The reason you want to do that is because generally, when we're looking at layoffs or unpaid leaves, employers don't have a right to implement them by default. So when employers implement layoffs, the only two ways in which they actually can do it lawfully is if there's been a previous layoff and the employee went on a leave or an unpaid leave or a layoff, came back to work, business as usual, you didn't claim constructive dismissal, you didn't raise an issue, you just went back to work and continued working, that creates a precedent, and then the employer is allowed to lay you off again in the future. That's one way in which a future layoff can be lawful. The other way is if, as an employee, you've signed something. So if you've signed an employment contract or any other kind of document that says you agree that the employer is allowed to put you on a layoff or an unpaid leave, then that becomes a term and condition of your employment. So in those scenarios, the employer is entitled to, by law, implement a layoff or an unpaid leave. So you want to make sure that if you're going back to work after any of these scenarios, you're making it clear that you're not accepting this as a condition of your employment moving forward. And that's why if you are going to pursue a constructive dismissal when you're put on an unpaid leave or a layoff, it's important to move forward as quickly as possible and make it known right away that you do not accept this, because it's not as strong as a legal position if you're doing it while you're returning to work. You have to do it during your leave in order to make it clear that you don't accept it. And so in that situation, if you are going back to work, that's what I would recommend. Make it clear that this was a one-off. This does not mean that moving forward, they're allowed to do it again, because you don't want to allow the employer to have that precedent they can rely on and do it again in the future. So I have a question from JC2004X on YouTube, who says, during the pandemic, I have discovered that some of the contracts have changed for some of my employers. Some companies have lost contracts. One example, I was working for the company in 2 different departments. One closed up years ago and the other closed up during the pandemic. I heard about this from another company that I work for that apparently picked up the contract. Okay. Should I seek severance? If so, how would that impact any chances of employment or possible seniority? Should I try to work with them in a different province later? Okay. So if you were actually let go, then you would be entitled to receive severance. It's not clear from the information you've provided when you say that the contracts have changed. If you're talking about, your former employer or your employer's customers or clients, those things may change, and especially during the pandemic. But at the end of the day, the question is, have you been let go from your job? If you've been let go from your job by either your employer outright telling you you're fired, we're letting you go, or if you were put on a layoff, as I just mentioned, if you were put on a layoff but they weren't allowed to put you on a layoff, which is the vast majority of people, then you can also pursue that as a constructive dismissal and go after your severance. So in any of those scenarios, you'll want to get in touch with an employment lawyer. You can contact us and discuss your situation with us. We'll be able to go through everything with you and figure out exactly where you stand. And if it is, in fact, a situation where you've been terminated either outright or by a layoff, and you are owed severance, it would be our pleasure to assist you and pursue that for you. So definitely get in touch with us, because it sounds like your situation might be a little bit complicated, and we want to make sure we talk about every aspect in order to make sure we're giving you comprehensive legal advice. I have a question here from Rocket on YouTube, who asks, is an employer micromanaging you at work a constructive dismissal, especially if they're watching you throughout your whole shift and being very nitpicky? Very good question, and one that actually I get pretty often. So in terms of constructive dismissal, what's really important to know is that not every change or potentially uncomfortable situation at work will amount to a constructive dismissal. Generally, when we're talking about constructive dismissals, we're talking about changes to the terms and conditions of your employment. So when an employer unilaterally, meaning without your consent or your agreement, makes a significant change to a fundamental term of your employment, that can trigger what we call a constructive dismissal. because the new change is such a significant change that your employment relationship cannot continue. So it's the same as essentially being let go, or your employer saying you're fired, but they're not actually saying it. That's why it's called a constructive dismissal. Now, examples that we usually see are demotions, reductions in pay. Somebody gets their pay reduced by 30% or has their hours cut in half, or maybe they've worked the night shift for 10 years and now they're being told they need to work the day shift, or vice versa. Other examples are, changing the work location 2 hours away, or somewhere where the traffic is so bad that it'll take you an extra hour to get to work each way. These are all examples of what could be a constructive dismissal depending on the circumstances. Another category, which is what this question touches on, is toxicity in the workplace. So a toxic workplace, an unsafe workplace, those situations can also amount to a constructive dismissal, but it does depend on the circumstances. So when we're talking about a situation of harassment in the workplace or bullying, or essentially a workplace that has become so unacceptable, so terrible that someone simply can't work there anymore, and then that would trigger that constructive dismissal argument, it has to rise to a very high level. So from a legal perspective, the threshold is very, very high. And so I'll give you examples of basically things that are unpleasant that wouldn't necessarily amount to a constructive dismissal. So if, someone in the workplace is not greeting you every morning, you're walking into work, you're saying good morning, maybe that person is not answering you, or when you leave for the day, they're not saying goodbye. A lot of people would consider that to be an unpleasant situation, but that kind of situation doesn't amount to the type of harassment that is so egregious that a constructive dismissal argument would be triggered. Similarly, when we're dealing with issues with management, which comes up very often, there is a certain amount of managing or maybe micromanaging that is permitted at law. And decision-making is also under management's discretion. So if, for example, your manager is making decisions that you disagree with, and you think that your manager should be deciding the decision, making the decision in another way or considering other factors, unfortunately, that doesn't necessarily amount to harassment or constructive dismissal. It would amount to a disagreement, but it does fall under a manager's discretion. So when it comes to managing or micromanaging, there is quite a bit of leeway that management has in terms of following your performance and overviewing everything and overseeing what's going on. There is quite a bit of leeway there in terms of what management can do. Where the micromanaging starts to get into the territory of maybe a toxic workplace or harassment is if the manager is constantly on you, constantly emailing you, berating you about the things you did wrong. Every single thing you do is wrong. Being unpleasant, being rude to you in terms of your performance issues. And it's a constant issue. You feel like you're maybe being set up for failure, where you're being asked to do something without the right guidance or direction. And when you ask for it, it's not being provided to you. These are the types of situations that a lot of the time are in the gray area, but depending on the circumstances, they can lead to an unworkable workplace and a situation where a constructive dismissal can occur. So if you're in doubt, if you're in a situation where you're just not sure, because oftentimes these situations, when we're dealing with this category, it is often in the gray area when we're dealing with various issues that are coming up in the workplace, micromanaging, performance issues that are not being addressed properly. That's where you absolutely want to contact a lawyer early on. Don't wait until you've had this issue going on for 6 months or a year or longer. Contact a lawyer right away. Contact us right away in order to discuss the situation with a lawyer, because it's important to know where you stand early on so that you can actually do something about it if there is something that can be done from a legal perspective. Because oftentimes you are able to do something about it, but you have to act quickly. If you endure this type of treatment for months and months and even years, you're not going to be able to treat it as a constructive dismissal because you've allowed it to go on for so long. So in these situations, time is always of the essence. If you think you're being mistreated at work, if you think that there's an issue that needs to be addressed and you need a legal opinion on it, get in touch with us right away and we'll figure out what your situation is, what the law says about your situation, and what your options are. Because again, if you wait too long, you might lose the ability to do something about it. So always contact us right away and you can figure out what you can do about these things. Even if something doesn't necessarily amount to a constructive dismissal, there are other things that can be done in order to help improve your workplace and be able to continue your employment and make it more pleasant for you as an employee. So certainly you should get in touch with us regardless of the situation, and we'll help you as much as we can, however we can. All right. Just getting through the rest of these questions. So I have a question from Steph D on YouTube who asks, under what you said about layoffs, if you are paid under the EI sub program, would that be considered a paid layoff and not apply with what you just identified? So when you say the sub program, there were a couple different EI programs, especially throughout the pandemic. There's the wage subsidy. So if you are working, for example, half a week on and half a week off, and there's a wage subsidy, then that wouldn't necessarily be a layoff. If you are receiving EI benefits during your layoff, that won't affect the legal analysis at all in terms of asserting it as a constructive dismissal. So if you were getting EI benefits, you were put on a layoff, and you're getting EI benefits from the government, that's a separate issue. So vis-a-vis your employer, you've been laid off. Your employer is not paying you, EI is paying you. That's a layoff, and you can pursue it as a constructive dismissal depending on the circumstances, but generally speaking, you'd be able to do that. So I'm not sure when you say the sub program, I'm not exactly sure which program you're talking about and exactly what your circumstances were. But if you want to send me an email, Steph, feel free to send me an email and clarify, and I can give you a more comprehensive response about your specific situation. You can go to employmentlawyer.ca and get my email address and just email me there. Happy to answer your question further for you. Okay, so I have a couple more questions here. I'll do my best to answer the last couple questions with the limited time we have left. I have a question from Luis on YouTube who says, I was fired because my previous employer said I did not meet their requirements for my job. I completed all tasks required, but I used COVID-19 paid time off the month before and also refused vaccination. Okay, so if you were let go because of a mandatory vaccine policy because you weren't vaccinated and you were terminated for cause and didn't receive severance, get in touch with us right away because we can assist you in terms of going after severance. You should have received severance if that's the reason for why you were let go, assuming there was no government mandate in place for your workplace or for the industry that you worked in. If it was a discretionary policy that your employer implemented, then definitely get in touch with us and we can assist you in pursuing severance. If it was unrelated to that, sometimes employers will let someone go because they say they don't meet the requirements for their job or it's not the right fit or whatever the case may be. And that is permitted at law. Employers can let you go on a without cause basis, meaning you are owed your severance, you are owed notice and or severance in that situation if you're not the right fit. And if they don't give you what they're supposed to, that's where you hear the term wrongful dismissal. So it doesn't really have to do with the fact that the employer might have been wrong to let you go, or they didn't give you a reason, or the reason they gave you was not a good one. It really is to do specifically with the fact that they didn't give you what they were supposed to by way of notice and or severance or termination pay. So it's not clear exactly why you were let go here, Luis, but it sounds like either way you are owed severance. So definitely get in touch with us and we can assist you in terms of going after what you're owed. I'll get to one more question. We're over time here, but I'll get to one more question. I have an extra few minutes this afternoon, so I'll get to one more question. And then if your question wasn't answered, please do contact us. You can email us at help@employmentlawyer.ca. You can go to our website, employmentlawyer.ca, contact us directly through there, and we'll be more than happy to help you. So this will be the last question for today. It's from Layla on YouTube. My employer is asking us to fill out and sign a return to work form. Does this mean it becomes part of our employment contract? Do we absolutely need to fill this form? So if you're going to sign something when you're returning to work, it is very safe to assume that it's going to become part of your terms of employment moving forward. So I would not recommend that you sign anything unless you get it reviewed by a lawyer first, because once you sign it, you're stuck with it. So even though you might feel forced to sign it, even though you might not want to potentially spend money on legal fees to have a lawyer review it, I strongly, strongly recommend it, because you are going to be stuck with whatever you signed. So I would recommend you get in touch with us and speak with one of our lawyers who can review that for you before you sign it, so that you know what you're getting into, so that you know what you're signing potentially before you sign it. The other part of your question is, do you have to sign it? The answer is no. A lot of employers have been doing this throughout the pandemic when they've called employees back from layoffs, or even now if they're calling people back from unpaid leaves because of vaccination policies. They're trying to get employees to sign a new contract, to sign a document that incorporates new terms and conditions of employment moving forward. And a lot of them are telling employees that they can't return to work unless they sign it. That's not true. You can return to work. The employer does not have to make you sign something in order for you to return. You can simply just return to work and continue working. So this is an example of the employer trying to take advantage of an employee who wants to return to work. I cannot stress this enough. Do not sign anything unless you get it reviewed by a lawyer first. And even then, once you find out what it says, once you find out what the legal consequences are, you might decide it's something that you don't want to sign at all, and you don't have to. So please be aware of that. Do not let anybody or an employer force you into signing something if you don't want to, and before getting proper legal advice about what exactly that document says. Okay. So that's all the time we have for today. Thank you everyone very much for joining us. Thank you for all of your questions. If you didn't get your question answered, please contact us in the methods I mentioned. And we also have several question and answer sessions next week as well. So you can ask your questions to any of my colleagues next week as well. So thank you very much and have a wonderful weekend.